Welcome everyone. Good morning. I hope you're all doing well. We'll take just a minute to let everybody join us and we'll get started momentarily. All right, we're going to go ahead and get started. My name is Jamie Beck and I'm the president and managing attorney of Free to Thrive. And for those of you that are not familiar with Free to Thrive, we provide legal services and other support to survivors of human trafficking. Today, we have an incredible speaker. We have Ugochi Annabary Nicholson, who is the directing attorney of Housing and Homelessness, the Housing and Homelessness Prevention Unit at the Public Law Center. And she'll be talking to us today about eviction defense in a COVID-19 world. And the reason we decided to do this training is what we've seen at Free to Thrive with our clients, and as everybody is seeing right now, that this is a really vulnerable time for tenants in our community and communities around the country. And the laws, the rules around evictions are changing rapidly, as you'll see today. And we wanted to give an opportunity for our advocates, our pro bono attorneys at other nonprofits to learn about eviction defense, and for us at Free to Thrive to learn about this topic so that we can better serve our clients. A few housekeeping items. We're on webinar mode, so you are all muted and your cameras are turned off. We do have the chat function available and also Q&A at the bottom of your screen. If you would like to ask a question throughout the presentation, please go ahead and put it into the Q&A. And we will be waiting till the end to take questions, but you're welcome to ask the questions as you have them. And with that, I will turn it over to Ugochi. Thank you so much for speaking to us today.
Thank you, Jamie, and to the Free to Thrive organization. Thank you for the opportunity to speak with you today. My name is Ugochi Annabary Nicholson. I'm with the Public Law Center. It's nice to meet you, especially in these unprecedented times that we are experiencing due to COVID-19. Before we get started, we'd like to run a quick poll to see who's in the room, like to get a sense of the audience. So if we can run that poll. Okay, I'm going to go ahead and stop the poll. A fair number of pro bono and public interest lawyers and a good mix of other attorneys and students in the room. Thank you so much. And a couple tenants. That's great. Sorry. Learning how to do this screen share. Okay. So I'm with the Public Law Center. We are Orange County's pro bono law firm. We provide free legal services to individuals in Orange County in a wide variety of civil legal aid matters, which we've done for close to 40 years. I supervise the housing unit at Public Law Center. So in our housing unit, we strive to provide access to housing for low-income individuals and ensure they have access to safe and dignified housing while they are in Orange County. And so we provide this through a number of services, including direct services, policy advocacy, and impact litigation. So the COVID-19 crisis has completely devastated and changed the landscape of the landlord-tenant market and relationship. Prior to COVID-19, there was 1 out of every 17 renter households were subject to eviction. And since that time, the numbers of eviction and mass eviction threats have increased. Estimates are about 19 to 23 million people nationwide are at risk of eviction. And of that number, 8 million people have experienced and expressed a no confidence in their ability to make the rent payment. And so we are about to head into another rent period. Today's July 31st. For a lot of tenants, rent is coming due tomorrow, August 1st, but legally August 3rd because we're on a weekend day. And so a lot of tenants are expressing angst and uncertainty about their futures because of the inability to pay rent due to COVID. So the COVID-19 has changed the landlord-tenant landscape. Many people have died as a result of the COVID-19 pandemic, and there are a patchwork of laws that have left tenants vulnerable during this time period. We're going to go through a couple of the executive orders that are in place right now, review the emergency rule that is currently in effect through the Judicial Council of California, and then have an opportunity to talk briefly about landlord-tenant laws in general. So there are local protections. However, they vary by jurisdiction. They are broad and some provide some narrow relief. Many of them across the board provide repayment periods for tenants who are unable to pay the rent due to COVID. For many of those tenants, it can range anywhere from 4 to 6 months to a calendar year to pay the rent back that they have not been able to pay due to COVID-19. In some parts of the state, some jurisdictions have allowed for no evictions to occur during this time period. And so for those jurisdictions that have no evictions occurring, those are the strongest protections that tenants have, because that means that during this pandemic and probably sometime thereafter, they are not subject to be removed as a result of the inability to pay rent due to COVID or for another reason, so they can safely shelter in place. It's best to check with the city where your property is located so that you can determine, if you're representing a tenant, whether there are existing protections for them in place, what those protections are, and whether there's any repayment periods if you are representing a tenant who is unable to pay the rent due to COVID. The governor, during this pandemic crisis, put in a series of executive orders designed to help with the eviction crisis. The limitation of these orders, however, are that none of these orders that are listed here, N-28-20, N-37-20, N-66-20, and N-71-20, are eviction moratoria. None of them prevent an eviction from taking place. What they did was essentially change the procedures by which an individual can be subject to the eviction procedures in court. So starting first with N-28-20, that came forth on March 16th, 2020, and that allowed an individual city to use the power that advocates believe that cities already have to provide eviction protections on top of what already existed under state law. So a number of jurisdictions use that authority to create procedures in place to prevent tenants from being evicted during the pandemic crisis, of which we're still in, I believe, phase 1. We have never really escaped phase 1. And so a lot of cities have used that power to create the moratorium that they have in their respective jurisdictions. So advocates continue to advocate for an eviction moratoria. So on March 27th, 2020, the governor enacted N-37-20, which allowed for the procedural changes to the eviction procedures to provide tenants who inform their landlords of the inability to pay rent due to COVID and document that inability within 7 days of being unable to pay the rent due to COVID, they would get additional time to respond to an unlawful detainer. Unfortunately, there was no guarantee that the tenant would avoid eviction, avoid displacement, but they would at least be able to get additional time to respond if they followed the procedures in which to respond to their landlords and inform them in writing and provide written documentation of their inability to pay rent due to COVID. That executive order has expired on it expired May 31st of 2020, and N-28-20 was slated to expire during the same time period. However, the governor extended N-28-20 to July of 2020 through N-66-20. And previously further extended N-28-20 through N-71-20. The other piece of N-28-20 is that under Penal Code Section 396, landlords are prohibited from increasing the rent more than 10% during this period of emergency. That's significant because a large number of the state is not subject to rent stabilization or rent control protections. And so for those units that are not covered under either state law, AB 1482, Civil Code Section 1947.12, or another rent stabilizing ordinance, there is no other protection for them other than Penal Code Section 396 during this pandemic crisis. So we also got, through the executive orders, opportunities for our Judicial Council to provide protections to tenants. And so that was via N-38-20. It gave authority to the courts to change its procedures by which, how they handle unlawful detainers. And so on April 6th, 2020, our Judicial Council enacted Emergency Rules 1 and Emergency Rule 2. So under Emergency Rule 1, the court allowed for the continuance of trials, eviction trials, from the 20 days in which they have to be set by statute to 60 days from the initial trial setting date, unless the court finds that a shorter trial setting is necessary to protect the public's health and safety. The other thing that it did most significantly was that it prevented the issuance of an eviction summons unless the court found in its discretion and on the record that an eviction is necessary to protect the public's health and safety. And so what that essentially means is that the landlord can still file an eviction after the issuance of a lawful eviction notice, because there's no rule preventing those actions from taking place. But what the landlord cannot do is get a summons that would bring the tenant and summons them to court to respond to the unlawful detainer during this pandemic period, plus an additional 90 days after the expiration of the governor's executive orders. The other thing that the Emergency Rule 1 did is that it prevented the individuals from obtaining a default, the landlord from obtaining a default or a default judgment, unless the court finds the following: that the action is necessary to protect the public's health and safety, and that the defendant hasn't appeared within the time that's provided by law, including an applicable executive order. So if you remember previously, we spoke about N-37-20 for tenants who provided the documentation that they needed to provide to their landlords of the inability to pay rent, and that inability was due to COVID, and that information was provided within 7 days, then their time to respond to a resulting unlawful detainer is increased to 60 days. And so no default can occur unless that time frame expires. The other emergency rule was Emergency Rule 2, and that relates to judicial foreclosures. Very few foreclosures in the state of California proceed judicially. So most of our energy as tenant attorneys have been focused on Emergency Rule 1. And so Emergency Rule 1 was not designed to be permanent. It was designed to help us get through this crisis so that we don't face mass evictions. However, on July 24th, the Judicial Council announced its intention to likely repeal Emergency Rule 1 around middle of August. So advocates are working with the legislature to address the resulting gap in an effort to avoid mass evictions. There are federal protections in place for individuals who are in federally subsidized housing or who reside in housing that is backed by a federal mortgage where the landlord received a forbearance on his or her mortgage during this pandemic crisis. The CARES Act, which is covered under sections 4023 and 4024, part of the CARES Act did sunset, and that relates to the 120-day moratorium that was in place under section 4024. For those tenants who fall under that section, their landlords must provide them a 30-day notice before they start eviction proceedings. And they must let that period elapse before they start eviction proceedings. For tenants who are under section 4023, i.e. they are in federally backed, or they're in a house that's federally backed with a federal backed mortgage, and the landlord obtained a forbearance, those eviction protections are still in place. And so they are not supposed to receive any eviction notices, and the moratoria are in place till around the end of August, if not later. So we have some resources at the end of this presentation that people can look at. The National Housing Law Project, for example, has a wonderful website and trove of materials for tenants, landlords, and the public to understand what the rights are of individuals who are in federally subsidized housing facing eviction, so that they understand what their rights are during this time period. So we'll take some time to walk through what an unlawful detainer is. The unlawful detainer process is commonly referred to in colloquial speak as the eviction. It is the legal procedure that landlords must use to remove a tenant from an apartment. The eviction procedures were designed to be summary in nature, to quickly restore the person who's supposed to be in the premises back to the property as quickly as possible. Evictions require a court process. Landlords are prohibited from self-help evictions, engaging in tactics that are designed to force tenants from their home without going through a process if they no longer want to rent to them. Compare that to a situation where a tenant voluntarily vacates, then a landlord can retake the possession without court process. Evictions are quite technical. Strict compliance is required, and failure to follow any strict compliance of the eviction process will result in the landlord having to start the process over. So let's get started. So under California law, the law presumes that a tenant is entitled to protections after being in a property for at least 30 days. It's important to know what type of housing your tenant has, or what type of housing you have if you're a tenant, because that will determine the rights and responsibilities between the tenant and the landlord during that landlord-tenant relationship. As stated previously, landlords cannot engage in self-help. There are laws that are prohibited to prevent that. However, the landlord can take steps to remove someone who is not a tenant, such as a trespasser, a licensee, an invitee. There are special rules related to people who are lodging, who are single lodgers in a landlord home where the landlord stays in the property as well. We're not going to go over larger rules today, but just know that for tenant protections, the person has to be a tenant. Any other type of relationship may not reveal that the individual needs to go through the eviction process to be removed from the property. So the eviction process begins with a notice. That notice has to be given in writing, and it has to be given to the tenant properly. The landlord can serve the notice, or he can have someone serve it for them. If the tenant doesn't timely correct the issues or does not vacate, the tenant is what's known as unlawfully detaining. And that's what starts the eviction process to commence again. Note, tenants who have a disability can request a reasonable accommodation for more time to correct the issue, or to get more time if they need more time to vacate the premises. I'll make a plug here for the Department of Fair Employment and Housing regulations. Advocates around the state, particularly advocates at the Disability Rights California, they wrote a regulatory authority that helped interpret the Fair Employment and Housing Act. The regulations are at 2 California Code of Regulations 12005 et sequitur. The ones governing disability and rights of people with disabilities is at 2 CCR 12176. So I would make a push for people to familiarize themselves with the regulations. They're great regulations. They help explain the law, and they're binding on housing providers in the state of California. So there are many types of notices that are at play in an eviction. The ones that appear on your screen are some of the most common ones that we see. A 3-day notice for people who are in private housing for failure to pay the rent, breach of the covenant of the lease, or a non-curable breach of covenant. 10 or 14 days for people who are in public housing, so federally subsidized housing. 30 or 60 days for people who are in private housing, who are not adjudged to have done anything wrong, but who the landlord is seeking to now have leave because of the end of their lease term. And there has been some changes related to the interplay between the 3-day and 30 and 60-day in the state of California with AB 1482. We now have just cause evictions in the state of California. And then the 90-day notice for those who receive federally subsidized, who receive federal subsidy assistance with their housing, they may be entitled to a 90-day notice. There are a whole body of law that deal with mobile homes in our state. This training does not go over that body of law because it's another highly technical area of law, but the mobile home residency law is at Civil Code Section 798 et sequitur. And that governs how individuals who own their mobile homes are subject to the eviction rules in the event that the landlord wants to evict them from the space that they are renting. For tenants who rent a mobile home, the private rules under the Civil Code and Code of Civil Procedure will govern their relationship with the landlords. There are also rules that protect individuals who live in recreational vehicles and how their tenancies begin and end. And believe it or not, there are protections for individuals and rules for individuals who live on liveaboards, so boats, how those evictions will begin and end, or it does relate that tenancy will begin and end. Okay. So we talked about just cause. So briefly, under Civil Code Section 1946.2, it requires 12 months in the premises to apply. If another tenant moves into the unit, that 12-month clock resets until one of the tenants has resided in the property for at least a minimum of 24 months, excuse me. The rules of just cause are presumed to apply unless the landlord informs the tenant that their tenancy is not covered under just cause. The just cause rules under 1946.2 Civil Code divide evictions into 2 types, fault and no fault. A no fault eviction, either 30 or 60-day notice, will require that the landlord waive at least 1 month of rent or provide them with relocation assistance. So in terms of the notice, and how the tenant gets that notice. Code of Civil Procedure 1162 provides that the tenant must either get notice in their hands personally, or the landlord can provide the tenant with the notice of eviction through another means, such as leaving it with someone who's suitable age and discretion, so someone who's 18 and over and lives at the property as well, or and mail the notice as well to the tenant. So give them actual, constructive and actual notice that they are seeking to evict them. Or they can post the notice to the property and mail the notice to the tenant. Again, giving constructive notice and then actual notice to the tenant that they've been served with the eviction notice because the landlord wants to end their tenancy for some specified reason. The service of that notice is jurisdictional, meaning that if the tenant can establish that they were never served with the eviction notice, then they can make an argument to the court that the eviction should not proceed because the landlord has not followed the strict compliance rule of serving them with the notice before commencing the eviction process. Okay, so we'll talk a little bit about the UD process and timelines. As I mentioned previously, it's a summary procedure. 5 court days is the shortest response time deadline for most UD cases. AB 2343 amended CCP 1161 in 2019 and gives tenants who are faced with non-payment of rent 5 court days to, 5 court days to 3 court days, excuse me, to respond to the unlawful detainer and to the non-payment of rent, or to pay the rent. And for individuals who are subject to a breach of the covenant, they also have 3 court days to respond. Unfortunately, the people who receive incurable breaches, such as a 3-day to quit, or a 30 or 60-day notice, those are not extended by court days, those run under calendar days. So it's important to know what type of notice your tenant has so that you can determine what their response time deadline is. But the 5 court days applies across the board, regardless what type of tenancy and what type of notice the tenant gets. They get 5 court days to respond. And there's additional time added when the tenant receives the eviction complaint a different way. If they receive it by substitute service or post and mail, they get an additional 10 days to respond. If the tenant responds, the court will set the case for trial, or the parties can try to see if they can work this issue out. About 80 to 90% of these cases do settle, so there's opportunity to try to settle the case with the landlord during this process of the eviction. If the tenant fails to respond, however, because this is a summary procedure, the tenant will be immediately defaulted and the eviction will move forward. So the complaint process begins with the summons and the complaint. There is no proper service without a summons. There's no proper service without the complaint. They have to go together, summons and complaint. The landlord can cause the tenant to be served with the summons and complaint via personal service, substitute service, or post and mail after an application and order from the court to do so. Once the landlord has served the tenant with the summons and complaint, the time for the tenant to respond will begin. Prior to that time, the court usually sends out a notice informing the tenant that there has been a summons and complaint for eviction, so that the tenant is on notice that there's an eviction complaint with their name out there. They're just waiting for it to be served on them. The complaint must be signed and verified by the landlord. That's also a technical requirement of the eviction procedures. And again, if that's not done, that's another defense that the tenant can raise to kind of slow down this eviction process. The notice of eviction must also be attached to the complaint. That's another statutory requirement under 1166. And if we've seen cases where the notice of eviction was not attached, everything else was pleaded properly, but the eviction notice was not attached, and we were able to get those evictions restarted because of that technical defense. So how may a tenant respond if they're evicted? There are a number of ways, but they're limited in an unlawful detainer. They may answer the complaint. They may demur to the complaint. That's the state function of a motion to dismiss in federal court, saying that the case should be dismissed because there is a deficiency of the complaint and the tenant's not able to properly respond because there's something fundamentally wrong with the complaint. Or a motion to quash service of summons because the tenant did not receive the summons properly. There was some defect in the service of that summons and complaint. So the court needs to start the process over and have the landlord serve them properly. Or a motion to strike some parts of the complaint. Compare, unlike other civil procedures, there is no right to cross-complain because the singular issue in an unlawful detainer is who's entitled to possession, what is the possessory right, and so there is no cross-complaining between the tenant and landlord in an eviction. The issue in an eviction is who should be there, so that's the only issue that's at play. After a tenant decides to, let's say, answer a complaint, there are some post-answer motions that the tenant can file. A motion for summary judgment, which is an evidentiary motion saying that there should not be a trial because there is no triable issue of fact that's of significance in this case. And so that's a legal motion, and a tenant can file that motion to end the case if there is no factual issue in dispute. So for example, if a tenant has been alleged to fail to pay the rent and the 3-day notice is defective because it charges more rent than the tenant legally owes, then one of the motions that a tenant can file is a motion for summary judgment. And then also the tenant can also file a motion for judgment on the pleadings, saying that there is a defect in the pleading, that this case should not move forward in some way, and the case should be summarily dismissed because the landlord has not met its burden to have them evicted from the premises. So if a tenant decides to answer the complaint of eviction, there are several defenses. This is by no means an exhaustive list. There are other defenses that a tenant can raise. These are the most common ones that we see coming up in unlawful detainer. Breach of the warranty of habitability. The landlord has failed to provide a habitable premises. They paid the rent within the non-payment period, so they haven't defaulted in some way. They repaired and deducted from the rent and notified the landlord they were doing that because of some defect in the property, and the landlord did not give proper credit. The landlord is retaliating against them in some way for exercising their rights as a tenant. They are a survivor of domestic violence or have contacted the police, and the landlord is seeking to recover the premises because they call the police too much, or they're a survivor of domestic violence. That was a recent update to the rules protecting individuals and survivors of violence. It's now prohibited in the state of California to move to evict somebody because they have sought law enforcement or emergency assistance in some way. It violates the AB 1482 notice requirements. The answer form, UD 105, is slated to change this September after some recent changes to Judicial Council form as following the enactment of AB 1482 to help tenants understand what their rights are and provide additional affirmative defenses that exist under Civil Code Section 1947.12, which is the state's rent cap of 5% plus CPI, and Civil Code Section 1946.2, which is the just cause eviction statute, or waiver that the landlord has waived, changed, or canceled the notice in some way. There are other affirmative defenses that you see coming up on your screen, and there are specialized defenses in subsidized housing. So good cause is generally required for those evictions. And again, it's not an exhaustive list because there may be other protections. And in this area of COVID, a lot of the eviction moratoria that exist provide an affirmative defense to tenants in their ordinances. And so that's another avenue that a tenant can use. If they're answering an eviction complaint, they can draw upon those defenses within the local ordinance, if a local ordinance so provides them with a protection. There is a form called the Prejudgment Claim of Right to Possession. This is a form that is attached to a summons and complaint for unlawful detainer that is served for other individuals who are not named in the lawsuit, if they want to seek to add themselves to the lawsuit so they can be heard in court, so that their rights are not impacted as the result of an eviction. There are strict timelines in which a tenant who's not named in an eviction who wants to add themselves to the case can do that. There are special rules for this form when it's a post-foreclosure eviction. In those evictions, this form can be done at judgment or post-judgment even. So it's important to know what type of situation you are in if you have a person who's not named in the eviction who wants to add themselves to the lawsuit. So the rules for prejudgment claim are CCP 415.46. Okay, preparing for trial, the tenant needs to watch out for the court date in the mail. The court will use the address that's provided for the tenant's response on the tenant's responsive pleading. We recommend to tenants who don't have safety in their addresses or don't feel comfortable using their addresses to get a PO box or use the address of a trusted family member so that they may receive the court's correspondence. And low-income tenants can and should file fee waivers to cover filing costs, including jury trial fees. So as I mentioned earlier, trials can happen as quickly as within 20 days from the date of the filing of the UD trial, unless they're slowed down for some other reason or the case is dismissed. The tenant will need to arrive to court on time, or they automatically lose when the judge or the commissioner calls their case. Generally, courts will take roll call at 8:30 in the morning and send the tenant and landlord into the hall. And this is happening virtually now because the courts are open but closed to the public to see if they can settle the case. And there are mediation services that exist to help parties negotiate settlement. So on the day of trial, the tenant should be prepared to bring all of their witnesses and exhibits and evidence forward if the parties aren't able to settle. Both sides must exchange exhibits or evidence if the case proceeds to trial. Most cases that are jury trial, for example, the procedures are done jointly. So the instructions are done jointly, the exhibit lists are done jointly, the witness lists are done jointly. So that means that you're trading with the landlord or the landlord's attorney, if they're represented, for the evidence that you plan to present at trial. And so when we were having trials in person, it was recommended that people bring 3 copies of the exhibits they plan to use for trial for themselves, the court, and the opposing party, so that it can be used during the court process. Okay, so the outcome at trial can be either the tenant loses, the tenant prevails at trial and continues to their tenancy, or the tenant does not prevail at trial and the landlord is given an immediate order of eviction, and then that is used to obtain the sheriff's writ of lockout, which then is used to evict the tenant from from the premises. That process takes anywhere from 7 to 10 days to get the writ of possession. That's the actual document that will be used to then evict the tenant from the property, because that gives the landlord the lawful authority to go and retake the premises. The sheriff receives that document, the writ of possession, and then generates the notice to vacate, which is then posted in a conspicuous place for the tenant. And then the sheriff returns 5 days after that writ is issued to then perform the lockout. Once the tenant is locked out, the eviction has taken place. If a tenant seeks to slow down that process, they need to appeal to the court on an ex parte to basically, on an emergency, to say, hold off, please give me an additional time to get my belongings together. Or if I'm appealing, please hold off while this appeal process goes through, and I'll be able to pay the rent for the days that I remain in the premises. Or the tenant can obtain what's called a stay of execution of the writ of possession. And so those are procedural steps that a tenant can use to stay the eviction. Or they can, if they're a person with a disability, make a reasonable accommodation request to the landlord, or even in court during the procedure of the eviction trial to see if they're going to be able to get additional time. So it's important to check the local rules and check the state procedures to determine whether or not a tenant is able to get a stay of eviction in the event they're in the position of that they lost the trial. I'm going to stop share for a moment because we have a hypothetical. And so I'm going to put the hypothetical up for folks. And then I'm going to stop share for a moment so that I can see the responses in the chat, the answers to this question. So people can go ahead and post what their answer would be to the hypothetical.
Can you put it up for just a
Sure.
bit longer?
Yes, I can. There we go. Okay. Let's see here. Okay, I don't see any answers yet. Oh. Okay. Oh, sorry, there is no poll. So if you can go ahead and put your answers into the chat box. Yes, correct. I'm seeing a lot of C's. Correct. Yes. So that is correct. So Tom, there's no just cause. The landlord can't get a summons right now during the emergency rule. And so Chom should be able to shelter in place. Exactly right. Okay. Oh, so sorry. Okay. So we spoke previously about rent increases. And so this is an issue that we're seeing right now during this pandemic period. Landlords increasing the rent during this period as a way to force the tenant to vacate the premises in the event that they can't pay the rent, or to force them in an immediate non-payment situation, and then try to breeze to victory in an eviction when they're allowed to get summonses again. So Civil Code Section 1947.12 caps the rents for tenants in housing that's covered under the statute. It's a 15-year rolling back period. So any new construction and certain types of other housing, like housing that has a subsidy in place, or like a college dormitory or hotel, motel, those are situations where 1947.12 doesn't apply. But for most housing that we come across, 1947.12 of the Civil Code is in play. And so that caps the rent at 5% plus CPI, unless the tenant is in a jurisdiction that has a stronger rent cap, subject to a rent stabilized ordinance or some other type of local protection. So that's why it's important to know what type of housing your tenant has, what city they're located in, so you can determine whether or not they have additional protection on top of what the state law provides as minimal protection. And for tenants who don't qualify for this rent cap or who don't have rent control, AB 1110 amended Civil Code Section 827 to provide 90 days notice for rent caps that are over 10%. Because we're in this period of pandemic, any rent increase is going to be also subject to Penal Code Section 396. And so for landlords who are violating Penal Code Section 396, tenants have another avenue as well to report those violations to the Attorney General, the State Department of Justice, and to their local officials and city attorneys or district attorneys if they are in a jurisdiction that has a stronger rent cap, or where the tenant is, where the landlord is violating Penal Code 396 because that's a violation of the criminal law. There are some cities and localities who are freezing rents during the pandemic. I practice in Orange County, and so we had 2 cities here who froze rent increases for residential tenants, Santa Ana and Buena Park. We believe that the Santa Ana ordinance is still in effect. There's some disagreement about whether that rent freeze is still in effect in Santa Ana, but the Buena Park ordinance that prevented rent increases during the pandemic, that's in effect throughout the life cycle of the ordinance, and including the repayment period, which in Buena Park is 4 months. So people in Buena Park have not only protections due to COVID, but they also have protections from the rent increasing. So it's important to check with your city to see if they have a rent freeze in effect. We've also seen an uptick in discrimination and retaliation during this pandemic period. It is illegal to discriminate against a tenant. There are statutory remedies available and attorney's fees available for violations of the Fair Employment and Housing Act, the Fair Housing Act, as well as a state or local procedures in place to protect tenants from retaliatory conduct for tenants who are exercising their rights as tenants to safe and dignified housing. Afflicted tenants can file, in the case of a discrimination on the basis of a protected classification, they can file a DFEH or a HUD complaint if they're in subsidized housing, in addition to an affirmative lawsuit. There are statutes and limitations that apply to DFEH, HUD complaints, and affirmative lawsuits based on illegal discrimination, and that is a 1-year statute of limitations for the Department of Fair Employment and Housing complaint, a 1-year statute of limitations for the HUD complaint, and a 2-year statute of limitations for any affirmative lawsuit of fair housing, depending upon which vehicle the tenant wants to use, Fair Employment and Housing or the Fair Housing Act. And that statute, the 2-year statute, could be told if during the investigatory process of the DFEH and HUD complaint. So it's important if you're seeking to redress a tenant's rights related to discrimination to think through whether or not you want to file a DFEH and a HUD complaint if applicable, and think through which avenue you want to go, either state or federal court. This training does not go through discrimination and retaliation because of the time, but just know that that it's illegal to discriminate against a tenant for a protected classification, and retaliation as well is illegal under the state laws. We're also seeing issues with utility shutoffs during COVID. And so it's important to note that the residents on multifamily housing, they're allowed to put utilities in their name when the landlord has stopped paying the utilities. And the electric company cannot require that the tenant pay the landlord bill as a condition of them transferring the utility into their name. There was a moratorium on shutoffs that relate to state regulatory agencies only, such as PG&E and Southern California Edison. That's up to and including April 16th of 2021. And there may be some other local protections as well to prevent utility shutoffs, but there is state protection. The landlord is not allowed under state law to shut off utilities or take any egregious act against a tenant to force them out of the premises at any time, but particularly during this pandemic. These are some helpful links that are out there that we use in our advocacy and that we are sharing with you in the audience today. They are really good, and there's really good information, especially during COVID-19. There's been a lot of misinformation and confusion out there about what tenants' rights are and what rights they have during this pandemic. So these are a number of links, helpful links, by no means exhaustive in terms of what's out there for tenants and their representatives to help them understand what their rights are during this crisis. We have an intake line for individuals in Orange County who seek assistance with understanding their rights as tenants. And so that's our number on the screen. And we inform tenants of their rights and what they can do during this pandemic and generally as tenants advocates. And so with that, I will stop share and see if there's any questions.
Goshi, thank you so much for that informative training. Extremely helpful, and hopefully will help a lot of our client population and so many others through this difficult time. And with that, I'm going to turn over to our senior staff attorney, Nick Moore, who is going to moderate our Q&A. All right, Nick,
hello,
what questions?
Everyone.
And if you haven't had a chance to ask any questions, please go ahead and put those in the Q&A chat box at the bottom of your screen, and Nick will go through them with Ugochi.
Please, yes. We are definitely looking forward to hearing from your questions. We have a couple of questions in the chat box right now. Seth has a couple of good questions just sort of along the lines of what is happening on the ground in terms of legislative efforts to address this crisis? Like what do we see sort of the future of the law, either legislatively or the Judicial Council in terms of how they're going to address this pending eviction crisis?
That's a great question. There are two bills pending in the legislature right now, AB 1436 and SB 1410. AB 1436 is the bill that's being forwarded by tenant advocate groups, because what AB 1436 would do would be to remove non-payment due to COVID-19, non-payment of rent due to COVID-19 as a cause of action under CCP 1161 off the table completely, and then create a structure by which the landlord and tenant can negotiate for a repayment of the rent that wasn't paid. And if it's not paid, then provide a mechanism and vehicle for the landlord to pursue the eviction, strike that, the recovery of the civil damages through civil court, like through a civil procedure. So that would be significant, because I think there's going to be a large percentage of evictions that are going to be related to non-payment of rent due to COVID. Right now, those would proceed through the normal channels of eviction. So the tenant would get a 3-day notice to pay the rent or quit, which could be substantial during this process. And then if the tenant doesn't pay that, then they're immediately thrown into eviction proceedings. So AB 1436 would proposes to completely remove that mechanism off the table, and then allow the tenants to proceed in a different way with the dealing of that debt owed to the landlord. SB 1410 would resolve it by way of tax credits to the landlord that are voluntary, and then provide a moratoria of evictions that wouldn't be permanent, but a moratorium broad-based. So there's discussions about whether to bridge those two bills together or to have them dealt with independently. Both are being heard in the Assembly and Senate through the hearings, I believe August 12th. So it's not really a whole lot of time before the Judicial Council rule is proposed to sunset. It's not a whole lot of time. So advocates are working feverishly to see what can be done legislatively. The Judicial Council, it's unclear whether or not they're going to move any further. Initially, this emergency rule 1 that we talked about previously was supposed to, this Judicial Council was proposed to eliminate the rule in June, but advocates fought and spoke with the Judicial Council, and they decided not to sunset the rule at that time. So they've kind of squarely put it in front of the legislature to deal with, and so we're hoping the legislature does act.
And before we go on to the next question, there was another piece to Seth's question that I don't want to lose, which is a practical piece of so many of the tenants right now who can't pay their rent, they don't have the means to catch up on rent at any point. There's, the stark reality is that there are people that are not working, and it doesn't appear that they'll be able to go back to work anytime soon. And I think, I don't know really what the question is, other than how do we grapple with that reality? I mean, is this process really just delaying the inevitable, which is they will need to move? And is there any like kind of bigger picture policy in works of how we can help people through this crisis beyond, a $1,200 stimulus check?
Yes, I mean, there's federal money through the Community Development Block Grant, Emergency Services Grant that are available for entitlement jurisdictions who receive those funds, and they can use those funds to help stabilize tenants. A number of jurisdictions in California have used money to help stabilize tenants, creating local programs where tenants can apply for rental assistance. Where we practice in Orange County, a couple of cities have created programs for tenants to apply. The only problem is that the sheer numbers of individuals who are in need of that rental assistance, the money's not infinite. And so we actually do need some type of stabilization legislation in place to say you can't evict, so that people can kind of reset, get restarted. Whole industries can either, reset, restart, because there are people who are going to have to retrain. There are people who are going to have to just completely figure out life kind of as they know it because of what's been happening economically with the pandemic. So people have been advocating nationally and locally for more financial assistance to be given to jurisdictions so that they can use that money on the ground to help people stabilize who are unable to pay the rent.
That's excellent. Thank you very much for that. Kind of as a follow-up, I suppose, David Habiff asks about, after 2008, landlords had to turn over their properties to the banks, and the banks were kicking out tenants. Are there, has the law sort of anticipated that this could happen again? And are any stopgaps in place? In the event that, we see a wave of foreclosure evictions?
Yeah, I mean, I think that advocates definitely have seen this again on the horizon. This is bringing us back to 2007 and 2008. And I think that's where the desire to have federal legislation through the HEROES Act. I think that's the more robust of the bills that were passed in the House. And then the HEALS Act doesn't mention eviction at all. So that's a little troubling. But the HEROES Act, I think, extended it 15 months, like for an eviction moratorium, and broadened the federal protections that exist under the CARES Act currently and previously under Section 4024, broadened that to cover more tenants. Because for the CARES Act, you have to be either in federally subsidized housing or your landlord has to receive some type of federal mortgage to bring yourself within that law. And so for tenants whose landlords don't receive any federal funds or aren't in forbearance of some type, they're not covered. And so there's this gap anyways that exists, but without legislative help and advocacy, I really don't see us not going back to where we were in 2007 and 2008, to be quite honest.
And I have one final question as we wrap up, which is really on the practical side of what are your recommendations for attorneys working with tenants of how do we help our clients through this crisis, given, you know, everything that you shared with us today in terms of the state of the law? What's your advice for us?
I think, you know, I know this may sound cliche, but to remain calm because there is a sense of urgency. And, you know, we are definitely fighting for an eviction moratorium. But I think if we remain calm as attorneys, we can help our tenants kind of think through what they need to do. We've been engaging in advocacy here at the local level to help the local jurisdictions understand why they need to provide broader protections on top of what the state and federal legislatures are doing. So if you're in programs or if you're an attorney who can lobby your legislature, because not every program can do that, you know, about broader protections that are needed to help stabilize tenants, that's one way. The other way is to actually advocate and assist the tenant with the landlord. We've been able to settle some of our cases during this pandemic, you know, through strong demand letters. We were able to, for example, save the tenancy of an individual of 20 years who was slated to be evicted because the landlord had issued a notice, and the notice came right at the beginning of this pandemic period. So we explained right after the emergency rule came down that he wouldn't be able to do anything. And so through that, we were able to settle that case. So we can, you know, helping tenants settle their cases through strong demand letters, contacting the opposing party to figure out what can be done, negotiating repayment plans on behalf of tenants. We've been able to do that and helping tenants understand that they do have rights and that it's an ever-changing thing. So kind of keep up with what's happening legislatively so that we can help our tenants understand what their rights are so that they don't have to flee during this pandemic, because everybody's allowed to shelter in place. The landlord can't evict a tenant without a lawful court order. And so reminding landlords of that. You may have to remind them 2, 3, 4 times about that, but just reminding them that they can't do anything without a lawful court order.
Thank you so much, Ugochi. And thank you not only for this training, but thank you for the work that you and PLC are doing for tenants through this crisis. It's so critical and more important now than ever before. So thank you. We're very grateful too for taking the time to train us today.
Thank you to the Free to Thrive, and thank you for the people who attended. You know, we have a group of advocates through the helpful links I gave in the materials. Just a lot of good materials to help tenants, user-friendly as well. And then also some are provided in English and Spanish. AB 1436 and SB 1410. Those are the 2 pending legislations in the state of California.
Perfect. Well, thank you so much. And for our attendees, we will be sending out the PowerPoint following today's training, along with MCLE certificates for attorneys licensed in California. So keep an eye on your email for that. And have a great Friday and enjoy your weekend. Take care,
Thank you.
everybody.
Bye, everybody. Thanks again. Bye.
Bye.